Hey folks, I wanted to make a video going over where we are in the United States v. James Comey case. Just exactly what's going on in the case at this moment, this weekend. And the reason I want to do it right now is because heading into the Thanksgiving week, there are two unique threats to this case, one of which we are expecting a decision on before Thanksgiving. And by threats, I mean the case could be dismissed. So the case of United States v. James Comey might get dismissed within the next few days. If you've followed my content for a while, if you've been paying attention to this case with me, thank you for joining with me. I've been covering it since the day it was filed, reading to you all the most important filings in it, making brief videos and long form videos digging into them. And we've been tracking the case together. And it's been a very enjoyable case to follow, but it's also been a complicated one. If you haven't before, please visit my link tree where you can find all the places to follow me, all the places to watch my content or listen to my content, and all the ways to support what I do here. I'm a document nerd. I love going to the documents in order to find out what's really going on. That's how I cut past the fake news, and that's how I cut past the reactionary takes that both influencers and media on the left and the right tend to put out every single day. I don't really like outrage content or reactionary content or cheap shot, social media dunking, viral junk food. I like digging into the documents and the nuance and the details of what is going on. And if you want to support that kind of thing, I would love your support. If you go to my link tree, you can find all the ways to support what I do. Benson Honey Farms, bootleg products, and Manly cans. If you use those links, they'll kick a few dollars my way out of your purchase. Ko-Fi.com keeps me caffeinated. And justhuman.substack.com is how you can support me month to month with a $7 subscription. That keeps me caffeinated. It also contributes to my Pacer fund. Getting these documents read and deciphered and then turning it into content takes time, and buying things on Pacer takes money. So thank you to everybody who subscribes to my Substack and who contributes in it whatever way you would like to. All right, James v. Comey, or United States v. Comey, I should say. This is kind of complicated, and I've given the background on this in multiple other videos. I'm going to do it more concisely now so that I can then describe to you the threat. So United States v. Comey is about two charges. Comey's false statement charge and then obstruction of justice, or obstruction of an investigation, okay? The district judge out of the Eastern District of Virginia who is handling the criminal case against Comey is Judge Nachmanoff. And in October, but he's one of three judges. That's where this gets complicated. Back on October 20th, one of Comey's motions to dismiss, he's filed like 3 or 4 of them by now. One of his motions to dismiss challenges the appointment of Lindsey Halligan as the U.S. Attorney for the Eastern District of Virginia. She is an interim U.S. Attorney. She was appointed to that spot after Trump fired Eric Siebert. Now, Eric Siebert was also an interim U.S. attorney serving for the Eastern District of Virginia. He went and served all 120 days of his interim appointment. And once 120 days were up, the Senate had not yet confirmed an attorney for this post. And by statute, what's supposed to happen is that either the president appoints someone else, or what usually happens is that the district judges vote to retain the president's interim pick until there is a Senate confirmed judge. Now, or attorney. Now, it's in the interest of the office to have a Senate confirmed attorney, because when the U.S. attorney is Senate confirmed, it's not that they have any more authority or power than an interim U.S. attorney, but it tells the judicial branch that person has the endorsement of both the executive branch and the legislative branch. That's the benefit of having a Senate confirmed attorney in that office, is that 2 branches have endorsed that person to serve as a U.S. attorney, a very powerful position. So when Eric Siebert's appointment was, or his 120-day interim appointment was up, the district judges voted to retain him as the interim U.S. attorney. Well, summer comes around, and Trump is wanting to see charges against James Comey and others. And there's a disagreement in the EDVA office as to whether or not there's enough evidence to charge James Comey. And there's a rumor, we don't know for sure, nobody has seen the document, but it was confirmed there was at least a draft declination memo circulating in the office advising against indicting Comey because there simply wasn't enough evidence. Trump fires Eric Siebert, or he resigns. It depends on who you ask. Trump then, in a very infamous or famous social media post, instructs Pam Bondi to appoint Lindsey Halligan to that office so that she can indict James Comey because he's a no good, very bad, dirty cop. Bondi does that. She appoints Lindsey Halligan as the interim U.S. attorney. Here's where the rub comes in. Comey's motion argues that Trump can't do that. He's already made an interim U.S. attorney appointment to that office. That person served the full 120 days. After that, the district judges voted to retain him as the interim attorney until there was a Senate-confirmed attorney to take the post. Trump has already used up his interim U.S. attorney play, okay? Something of note is that here's the order appointing Lindsey Halligan to that office signed by Pam Bondi, and she appointed Lindsey Halligan under 28 U.S.C. 546. We're going to come back to that later. Now, after this happens, after Comey files that motion to dismiss based on unlawful appointment of Halligan, Judge Nachmanoff then has to refer to the Fourth Circuit judge which covers EDVA. And the Fourth Circuit judge, the chief judge, Albert Diaz, has to bring in an out-of-circuit judge or out-of-district judge to handle this. And that's because it's challenging the U.S. attorney who is in charge of prosecutions in that district in which Nachmanoff works. So there's kind of like a conflict of interest thing there. And so the way what you have to do, and it says like right here, in the interest of maintaining public confidence in the impartial administration of justice, you bring in an out-of-district judge. And so Chief Judge Albert Diaz, who's chief of the 4th District, brings in senior district judge out of South Carolina, Cameron McGowan Currie, right? She's been at this since the 90s. She was appointed in the 90s. And she is only going to handle the issue of Halligan's appointment, okay? So now we have Nachmanoff is the district judge handling the criminal case, and we have Judge Currie, who is the out-of-district judge handling the issue of Lindsey Halligan's appointment and whether it was lawful or unlawful. Now, this is not the first time we've seen something like this happen. There have been defendants who have challenged the interim appointments of U.S. attorneys in New Jersey, Nevada, and California. And in all of those cases, some judge agreed that they were not lawfully appointed to their office. And I don't think any of them were altogether removed because after that judge ruled against their interim appointment, based on similar circumstances of it being a sequential, more than one interim attorney being appointed back to back, they were then awarded the status of special attorney by Pam Bondi. And their prosecution still went forward, but they were no longer the head of that U.S. attorney office. It's a strange situation, and I'll get into it a little bit more in just a minute. Now, after Judge Currie is brought in on this, she tells the government, I need you to give me all of the indictment signers. So that would be whoever was involved in signing the indictment of James Comey, all of the necessary documents and anything else in order for me to determine the extent of the indictment signer's involvement in grand jury proceedings. And that's because her appointment's been challenged. And if she is not legit, if she's not legally authorized to be the United States attorney for this office, then whatever indictments she's part of might get thrown out because she didn't have the authority to bring the indictment in the first place. Now, one example, over in California with Brad Asaley, he got removed as the interim U.S. attorney based on a similar situation to this, but the indictments held. No case was thrown out because he was not the only person who signed the indictment. Other prosecutors from that office also were part of the attaining of that indictment and the grand jury proceedings in those cases. So the cases still exist and are still being prosecuted because lawful, legally enabled and authorized prosecutors in that office also signed the indictment. That's not the case with Halligan. Halligan's the only person who signed the indictment of James Comey. So anyway, Currie wants to see everything having to do with Halligan's involvement in the indictment of Comey. Then on November 3rd, they're about to have a hearing in front of Currie to discuss this situation and these filings. And the United States steps in, as in Pam Bondi's own counsel in the AG's office, Henry Whitaker, who's the former Solicitor General in Florida, and he was a very experienced person. He used to clerk for Clarence Thomas. He also used to work in the Solicitor General's office of the United States and one other office. It escapes me right now. So anyway, he's a high power guy. And he comes in and he files this response to Comey's motion to dismiss based on Halligan's unlawful appointment. I went through this filing page by page in an episode of my podcast several episodes ago. I also went through Comey's motion to dismiss. And I'm going to, again, like I've said before, it changed my mind. This filing from Whitaker arguing that Lindsey Halligan is lawfully appointed used precedent, used history, used explanations of the statutes involved to change my mind into thinking that, yeah, Lindsey Halligan is lawfully appointed and I think she should survive this motion to dismiss. That doesn't mean she will. I'm not the senior out-of-district judge. I'm not a judge. So Currie may come in with a different take, right? I'm just telling you that I've read both motions in other videos, and I found this motion to be very compelling. I also found it just to be a good read. I like the way that Whitaker writes his filings. Also, when he made this filing, Pam Bondi, it turns out, had made an additional order appointing Lindsey Halligan to more I don't know, awarding her more power and another title, if you will, appointment of Lindsey Halligan as special attorney, and also ratifying the indictments of James Comey and Letitia James. So on October 31st, it turns out, nobody knew until days later, but on October 31st, Bondi saw fit to up the appointment of Lindsey Halligan, to level it up. You remember, originally we looked at it and it said she was appointed under 28 U.S.C. 546. That was the statute she was appointed under. But now Lindsey Halligan is appointed under 28 U.S.C. 509, 510, 515 as a special attorney. And she also has been given the special authority as special attorney to practice and prosecute specific cases. And those specific cases are United States v. Comey and United States v. James. In addition, Pam Bondi also said, I've reviewed the grand jury proceedings in both of those cases, and I hereby exercise the authority vested in me as Attorney General to ratify them, to ratify those actions and before the grand jury, literally what it says, to ratify Ms. Halligan's actions before the grand jury and her signature on the indictments. So Pam Bondi has come in and backed her girl in the EDVA. Now, there's a question over this order. Nobody questions that Pam Bondi can do this, that she has the legal authority to name someone to be a special attorney, to empower them. to prosecute cases, to delegate her authority as the AG to do these things. That's not in question. What is in question is her doing it retroactively. And I don't know the answer to that. I don't know that a attorney general can retroactively appoint someone under additional statutes and give them additional authority. But that's what Pam Bondi did. We'll see. This is one of the things that Judge Currie will be looking at, and I don't know that she's going to actually rule on whether or not an AG can retroactively appoint an attorney, but she's going to have to handle this order because it specifically says that Halligan is appointed to prosecute these specific cases. In the alternative, it says right here, in the alternative, should a court conclude that Ms. Halligan's authority as special attorney is limited, I hereby delegate her the authority to conduct and supervise the prosecutions in these specific cases. So we'll see. Now, special attorney is the status and the authority that she gave Brad Asaley and Lindsey Halligan and Chaga out in Nevada. And so far it's held, although there's ongoing cases related to that. But big endorsement of Halligan and the cases from the AG. And Currie will definitely have something to say about this. Now, next day, Judge Currie issues an order to the parties and says, look, I need to look at all the documents and I need to see the transcript. I need to see, for my in-camera review, meaning me, just the judge, I need to see the complete transcript and all the recordings of all statements made by the indictment signer to the grand jury. So made by Halligan. And I need to see all the grand jury proceedings because I'm reviewing what exactly she was involved with the grand jury. Because again, if her appointment is thrown out, it could be that some other prosecutor conducted the grand jury. And so it might stand. The indictment might stand. We know now that that's not the case, but that's what Currie is looking for. And she's got to get all her ducks in the row before ruling. So they had a hearing in front of Judge Currie, and she seemed very skeptical. According to reporters who were there, she seemed very skeptical of Halligan's appointment. She expressed that she was familiar with the other interim appointments that got tossed, which I've already mentioned. And she questioned the government about how this would work, and about Halligan's appointment and why it's lawful. And Comey's defense team argued that it wasn't in front of her. But then maybe one of the most interesting things is that this is where we got the confirmation that Halligan acted alone, which means if she doesn't have the authority to do it, then the cases could be thrown out. And then here's where we get the claim that by Thanksgiving is that the judge said that she would address this before Thanksgiving. I want to find that exactly. There it is. She said that her ruling on this would come before Thanksgiving. So that's why I said at the beginning of this video that the James Comey case could be thrown out before Thanksgiving. Now, post that hearing, one more thing. She also questioned whether or not the grand jury stuff was incomplete. She said right here that proceedings that led to Comey's indictment, a portion of them seemed to be quote unquote missing. And she asked the government some questions about that. And they tried to explain some of it, but it said that it appeared there was no record of the grand jury's final minutes and the final minutes of the grand jury session. So it looks weird. And the government came in immediately after that hearing and filed a notice trying to clarify the record. And then they came in and filed a declaration from Lindsey Halligan herself testifying as to what went down, swearing out in a filing like this. I declare under penalty of perjury that this is what transpired in the grand jury. And then AG Bondi made another filing saying, yep, I ratify the actions of the EDVA and under Lindsey Halligan's authority, and I ratify the grand jury indictments. I did see all of it. Nothing's missing from the record. And that's what Halligan says. Nothing's missing from the record as far as we're aware. Then there's another one. This was only the next day. Informative notice clarifying the record. Again, trying to describe what went down in the grand jury room and how things went. And then another filing, declaration of the interim United States Attorney for the Eastern District of Virginia. Again, another declaration. And then, or wait a minute, I may have had those up there twice. And then there was another filing, right here. Government's notice correcting the record again. And this time filing the grand jury transcript, or at least the end of the day, the transcript from when the grand jury returned the indictment. So just the proceedings that involve the return of the indictment in front of the magistrate judge. And so that's like 1, 2, 3, 4, 5, 6 documents filed. Maybe I shouldn't count Bondi's order. I won't count this one from Bondi. So that's 5 filings post this hearing in front of Judge Currie, trying to clarify what should not be that complicated or difficult to clarify. And yet they've had to make 5 filings to clarify it. And as I went over in a thread yesterday, they don't. They clarify a lot, but there's still some discrepancies. There's still some conflicting statements. And I get into those in this thread, which I'll make a different video about that. So anyway, I'll address that in a different video. So that's the number one threat, is that Judge Currie could dismiss this case by the end of the week, before Thanksgiving, I should say. So either on Monday, Tuesday, or Wednesday of this upcoming week, Currie could dismiss this case, and it would be dismissed because Halligan wasn't lawfully appointed, and she's the only person who signed the indictment. Therefore, she didn't have the authority to indict anyone, so therefore the case is dismissed. She also likely has something to say about Pam Bondi's retroactive order. And hey, it could be that she says that Bondi is not lawfully the U.S. attorney. She's disqualified, but under the authority invested, but that the AG invested in her, or vested in her, I should say, not invested. She's a special attorney. And so, and the AG has used her power to ratify the indictment and to endorse Halligan's conduct and handling of the grand jury. And so based on the AG stating, yes, this I ratify both the attorney's authority and the indictment, and I authorize her to prosecute these cases, she might say they stand. That Halligan is disqualified as interim attorney, but the indictment stands and Halligan is authorized to prosecute them. That's also something that could happen. Or James Comey could lose. And Judge Currie is convinced by Whitaker's filing, as I was, this one right here, and that she looks at it and she says, you know what? No, presidents can absolutely make sequential appointments of interim U.S. attorneys. All U.S. attorneys serve at the pleasure of the president. He is the chief executive, and all executive authority proceeds from him. And he gave his executive authority to Lindsey Halligan specifically to operate in that office. She's lawfully appointed. That could happen. I don't think that's the most likely outcome. but it could happen. Okay. Now, on to the other threat to this case. Okay. This run describing the second threat to this case actually involves more documents, more filings anyway. And it involves a different judge. So here's where the threat begins. Back on October 12th, after a scuffle, there had been a back and forth about the issue of discovery already. The parties had met, both prosecution and defense had met, and reportedly had agreed on just a standard discovery schedule. And it really shouldn't be that difficult because, after all, Comey's charged with a false statement to a senator in a hearing years ago. And so just prove that what he said in the hearing was false. And how could there be that much discovery to go through, right? And how could it be that difficult to provide the discovery to the defendant, especially the initial bat of discovery, which is Rule 16, which that's the discovery, the evidence that the government has against you. So just, you indicted him, right? Just provide it according to the standard schedule, and then, it's not that complicated. And the judge had said, Nachmanoff had said, he wants to move this case along. It's not that complicated of a case, but it definitely has turned out to be. But there's a discrepancy on the parties agreeing on a standard discovery issue. And as you can see right here, the government actually wanted to have two dates. They wanted to have two deadlines. They wanted the court to set two deadlines for its Rule 16 disclosures, which are the first set of discovery. One date for October 14th and the other one for October 20th. But Comey's team was opposed to that. The judge ended up denying the government's motion and setting a standard discovery schedule and saying, all right, by October 13th, you need to turn over all the Rule 16 stuff. And if the parties can't agree, then we're going to have a hearing on it later on. Well, October 13th rolls around, and they ended up issuing, either on October 13th or shortly thereafter, some 85,000 pages of unclassified discovery. Which, how can there be 85,000 pages of discovery in this case? I don't know, folks. It's almost like something more is going on here. So, but what they left out is maybe the most important discovery. And it has to do with potentially privileged materials that were seized pursuant to 4 search warrants from the Arctic Haze media investigation years ago that ran between 2017 and 2021, and that targeted Comey's, or actually between 2019 and 2021, targeted Comey and his attorney, Daniel Richman, who's person 3 in this indictment. They seized communications between Daniel Richman and Comey. And there's question about whether or not they could have done that. Like, legally, they should have done that. And this stuff is potentially attorney-client privileged, meaning they shouldn't be able to use it against Comey unless they can get that protection pierced by a court order. And so the government files their first motion. They held this discovery back because it still needs to be filtered. And they filed a motion to Nachmanoff for the implementation of a filter protocol. A filter protocol is when a team of lawyers and investigators come in, and they're usually from out of district, and there's a line of impartiality there, and they're supposed to look at the material and separate out what might be attorney-client privilege from the stuff that definitely isn't, and then whoever is the privilege holder gets to assert their privilege over the material, and then a judge will take a look at it, or a special master, and they will, which will be somebody appointed by the court, and they'll decide whether or not there's an exception to the attorney-client privilege protection there. Might be because there's crimes discussed there, or there's something there, like there's a veil, the protection, for some reason, the protection on it is not valid. And when that happens, if that's removed, then the prosecution can use those messages or that material against the defendant. But if it stands, then the prosecution doesn't get that material. So this is very important. And it honestly should have happened before Comey was indicted, unless this is part of the plan. So anyway, October 13th, they file a motion for a filter protocol. 6 days later, they file a motion urging the government to, actually 5 days later, they file another motion to expedite that filter protocol, saying, please, Judge, we need to review this evidence. In fact, this evidence could be exculpatory or inculpatory, but we don't know right now because we need it to be reviewed through a filter team so that we can inform the potential, we can be informed on the conflict. And we also think that there is a potential conflict and disqualification issue here for Comey's lead counsel, Patrick Fitzgerald. We think that he maybe shouldn't be involved in this case. So that's another reason why we need you to hurry, expedite your ruling on this, please. Okay, well, Comey's team comes back immediately. I was watching the docket that day. It was a couple hours later it was filed, saying, no, do not hurry your decision. One, we haven't replied to the motion for a filter team yet, and it's our right to do so under Local Rule 12. We also get 2 weeks to do so. So we don't even have to reply to that motion for another 10 days. Well, not 10 days. I shouldn't say that. Another 9 days. Also, we would like to challenge the underlying search warrants because there might be a problem with those search warrants. And we're not sure that these materials were lawfully seized in the first place, and Comey's Fourth Amendment rights might have been violated. So before the prosecution goes ahead and violates his Sixth Amendment rights, we want to make sure the warrants themselves didn't violate his Fourth Amendment rights. So we're against the filter protocol because we want to challenge those search warrants first. But we'll have a motion on it later. The judge comes in and says, yeah, actually, government people, I appreciate what you're trying to do here, but under the rules, they have until October 27th to reply, and I'm going to give that to them. They ended up, did I put that twice? I think I put that twice. No. So they ended up replying, and I may have messed up my motions here. Hold up. No, I just left out Comey's motion, I think. All right. So the government replied, or no, Comey's team replied and argued against the filter protocol and that they wanted to challenge the search warrants. The Judge Nachmanoff ended up bringing in a different judge, and he ended up bringing in Magistrate Judge William E. Fitzpatrick to preside over all proceedings related to the potential review of privileged materials in this case. And that's in accordance with a precedent-setting case that's active in the Fourth Circuit, and that, it's a and bringing in another judge to handle an issue of a filter protocol and the attorney-client privileged or potentially attorney-client privilege material in a case is not without precedent, as I said. And he's doing this, as he says in his order, because of guidelines set forth in a case called In Reply to Search Warrant issued on June 13th, 2019. I don't know what that case specifically was about, but it had to do with a Baltimore law firm and DOJ using a filter team to go through some material. And so there's a precedent for this. And I'm pointing this out because I don't want people to get the impression that the judge is bringing in a buddy of his to, try and, there's something unethical here. I don't believe there is at all. In fact, I think this is the judge being careful, right? Getting another opinion on this. And also, this case is getting more complicated. All right, so he issues the order. Nachmanoff does. And Fitzpatrick comes in and says, okay, I need you guys to show me some of the materials that are relevant to this. And we are going to have a hearing on November 5th about it. So go ahead and make your filings on your positions as to, what we're going to talk about in the hearing and what your stance is on this issue. So the hearing happens. And after the hearing, Judge Fitzpatrick issues an order saying, all right, the government's order for the filter protocol is denied, and I'm going to order the government to produce all the materials that were seized pursuant to those 4 search warrants I want to see all the materials that were seized, and I want to see them in whatever form you currently have them, which is going to become important because they haven't been parsed out. Also, he orders that the government to provide to the court and to the defendants information regarding the status of the production, including any anticipated delay. And I want all of this given over by November 6th. And then he goes into more specifics here. I want the government to confirm whether it has divided the materials in the search warrants. I want to know if it's divided from responsive and non-responsive to those warrants. So those warrants were about different crimes from what's charged here. And those warrants specified what type of materials were supposed to be seized. So I want you to explain to me, are they parsed out to where it's responsive and non-responsive? And I want a detailed explanation as to the methodology used to make that determination. Wants a detailed explanation and for what period of time the government has preserved those materials that are identified as non-responsive. Also a description identifying which materials have been identified as responsive, and a description identifying which materials have previously been designated as privileged. He also ordered the government, including any agents or employees, to stop reviewing them, not to look at them at all. Whatever materials they're going through, cease that. And order that the government shall produce no later than 5 p.m. on Thursday, November 6th, and file in the docket under seal all documents relating to the grand jury proceedings, including audio and the transcripts and testimony by law enforcement, by witnesses, by the prosecutor that was given in the presence of the grand jury. So remember, the other judge, Judge Currie, had requested all the materials that had to do with the grand jury proceeding that involved Lindsey Halligan and transcript of the proceeding. Now we have another judge who says, I need to see everything having to do with that grand jury. All the materials, recordings, witness statements, everything. And the reason for this is because there is a strong suspicion, it was articulated at the hearing and in a filing, and more filing since then, that some of this privileged material made its way into the lead FBI agent on the case became aware he was exposed to some potentially attorney-client privilege material in the lead up to the grand jury, and then that same person served as a witness to the grand jury and may have conveyed some of that attorney-client privilege to the grand jury, which would be a huge, huge big problem. Cannot do that. One, he shouldn't have been exposed. Two, since he was exposed, he shouldn't have been testifying. And one of the reasons that it is strongly suspected that he was exposed and that he then testified after being exposed is what's described in the indictment, one. And two, we know that he was pulled off the case. That shortly after testifying to the grand jury, the Office of Legal Counsel at the FBI pulled him from the case completely because of this exposure. And then he tells both sides to file their motions pursuant to the search warrants and, what their positions are on them. So it was, let's see, this doesn't have a date on it. Why doesn't it have a date? Hold on. This one this order came down on November 5th. Why doesn't this next one have a date? I'm not sure, but it's a copy of the same. Oh, it's filed. Okay, it's filed. I opened it twice. Okay. Well, the government appealed this order. They appealed it to Judge Nachmanoff, saying that we don't agree with disclosure of the grand jury materials. We don't want the defendant to see them. We don't agree that he should have them. And I think I'm missing a filing in all of this. Yes, I was. I'm sorry. Before that order came down, Comey's side had made a motion for the government to disclose the grand jury proceedings to his side. And in this motion, he described all of the irregularities with the grand jury that justify the seal of secrecy that grand juries are normally under being removed. And I think it was 14 different irregularities. It might have been less than that, but there were a number of irregularities. I made a big list on it and I did a video on them, and they're significant. Now, some of them are definitely a defense team doing their best for their client and trying to make, something seem more irregular than it actually turned out to be. But other ones, it's enough to make you go, that's weird, and that needs to be cleared up. Okay. And the magistrate judge Fitzpatrick was compelled by that. He was convinced of this, that this needed to be disclosed to the defendant, that they had done what they needed to do to get grand jury secrecy removed, and they should be able to look at the materials from the grand jury and the proceeding, analyze it in search of a basis for a motion to dismiss. Now, you're not really supposed to be able to go and look at those things on a fishing expedition. The standard is you have to have particularized and evidence-based, and those are the words used: particularized and evidence-based reasons for unsealing the grand jury materials. Like, the defendant has to have evidence that is very specific as to what they believe occurred with the grand jury. Here's why they believe it occurred, why it's a problem. So therefore, the grand jury proceedings should be unsealed and provided to the defendant. And that's what Fitzpatrick found after his first pass. That's what he looked at. He looked at the materials and said, "Yep, it's there." And the government needs to provide it both to me, all these materials to me, and they need to provide it to the defendant. Well, that didn't go over well with the prosecution. And the prosecution appealed the magistrate's order immediately, saying, no, we do not believe that the defense has met their burden to have this stuff disclosed. And we also think that the magistrate judge exceeded the scope of his delegated authority. He was supposed to decide on the stuff having to do with the filter team and the privileged material, not the grand jury. He can't order this. And they appealed to Judge Nachmanoff. Judge Nachmanoff took a look at it and said, no, actually he didn't. This is within his authority, and I'm remanding the issue back to him for further proceedings. So they don't have to comply with the order yet, but they have to have further proceedings on it. So Judge Fitzpatrick, and I'm sorry if I call him Fitzgerald. Comey's attorney is Fitzgerald. His lead attorney is. Fitzpatrick is the magistrate. So Fitzpatrick comes in and says, okay, you guys didn't want to comply with my order. Well, the other judge said that, nah, I didn't exceed my authority. And he remanded the issue back to me for further proceedings to determine whether there are particularized and factually based grounds for disclosure. So I'm ordering a telephone conference. I'm ordering you guys to file additional briefings on the docket to convince me of your argument on this. So Comey's team filed another motion or another brief. All right, you guys, this is what your order was. Here are our reasons for why we need it. The government filed additional briefing saying, nope, Comey's just speculating. He hasn't met the burden of undoing the grand jury secrecy, which is something that all grand juries have. It's a very, very, very high bar to get past. Grand juries should be secret. There's all these great reasons why they should be secret. And in order, Comey can't go on a fishing expedition. He has to have very specific evidence, and he just hasn't met the bar. The bar is very high to get this stuff unsealed, Judge, and he hasn't done it. They also filed an affidavit from one of the FBI agents, Francis Nero, who was involved with the material that is potentially privileged. They also have an affidavit from Special Agent Spencer Warren of the FBI, who was also involved. Curiously, they didn't file an affidavit from the agent who was exposed. That kind of stands out. Well, they had the hearing, and it was a telephone conference, and it was very short. It only lasted 8 minutes. And the court requested that the government produce to him, and him only, all materials relating to the grand jury, including the grand jury instructions, transcripts of witness testimony. Remember, the only witness was the exposed FBI agent. and any other communications with grand jurors and exhibits that were produced at the grand jury. Okay. So now they're having to do the same thing for two different judges. Give them all this grand jury stuff. All right. He looked at it and he said, I want all that stuff. This is official order where they went into more detail about what all he wants. And then he also ordered the defendant to submit ex parte, meaning just to him, the judge, what it is that they think the grand jury disclosure is going to assist them in. The defendant may submit an ex parte filing to assist the court in its review of the grand jury materials. We don't have that. It only went to the judge. So we don't know what it is that the defense put in that. Not at this time. Prosecutors come in and they file a response in opposition to Comey's motion for disclosure of grand jury materials, arguing again how he hasn't met his burden, and he alleges that there's multiple constitutional violations and that the procedure was highly regular. We're telling you, no, that's not true. It was very regular and it was completely constitutional, Judge. The judge has a look at it, has a think. I think a week goes by maybe, and he issues an order where he goes into detail. It's like 24 pages, and I have a video on it. He goes into detail about each and every irregularity with the grand jury proceeding and each question that arises based on his overview of the grand jury materials and all the things. In fact, he makes 11 findings, and I have a video going over this in detail. He ends up making 11 findings of irregularity that establish a reasonable basis to question whether the government's conduct before the grand jury was reckless or it was disregard. He identified two statements from Lindsey Halligan that ran contrary to the law. He identified questions about that same segment that Judge Currie brought up in the hearing that was like, what did you do here? Because it seems to be that there's something missing from the grand jury proceedings. And so he orders them to turn all this stuff over. Yeah. You need to turn over all those materials to Comey's team. Well, Halligan immediately files an emergency motion to stay, to pause that order, and appeals the order to Judge Nachmanoff. Okay? Comey opposes that motion to stay, but says down here, all right, if you are going to grant the stay, then let's hurry up and let's do it before the end of the week, before November 19th. Each side should submit a motion lodging their objections one way or the other. And Judge Nachmanoff, who's back involved again with this issue, says, okay, by Friday, or actually by Wednesday, the government should file its objections with me, which they did. And the defense should file any response by Friday, which they also did. And then they had a hearing. Now, this hearing with Judge Nachmanoff was not supposed to be about attorney-client privilege or the filter team or the grand jury or anything like that. This was already scheduled on November 19th, this hearing, and it was supposed to be about a different motion to dismiss by Comey. The motion to dismiss based on vindictive and selective prosecution, which I do not believe that Comey is going to win out on. Okay? But Nachmanoff, while he's at this hearing, it happens, Lindsey Halligan is there in front of him. And he has all these questions about the grand jury proceedings because what just happened? He just read this 24-page order from Magistrate Judge Fitzpatrick, who for the second time ordered the prosecution to turn over all grand jury materials to the defense due to particularized and evidence-based reasons of particularized and evidence-based reasons that are like they believe that there was a Fourth Amendment violation, a Fifth Amendment violation, a Sixth Amendment violation. There's stuff seized outside the scope of the original search warrants. a tainted FBI agent testified to the grand jury. What we know about the transcript and the grand jury proceedings, it looks like there was stuff that happened outside of the record of the grand jury proceeding. I think I already said Halligan made those 2 misstatements of law. So there's all these issues, and they're not just speculation. They're based on something documented that doesn't make sense, or that a judge has seen, Judge Fitzpatrick has seen, and it is not right. And so Nachmanoff has just read this order. He's become familiar with this issue. It's the second time it's come up to him, right? And the first time he remanded it back to Fitzpatrick for more proceedings. And Fitzpatrick held those proceedings, looked at the briefs, and again, in a more he wrote this, it's actually a really good filing, articulating all of these things that may have undermined the integrity of the grand jury proceeding. So therefore, this is a case, there's a rare example of a criminal defendant who actually did make a particularized and factually based showing. That's the word I was looking for a while ago, a showing that grounds exist to support the proposition that irregularities may have occurred in the grand jury proceeding, and that those could lead to the dismissal of the case. So at this hearing that's supposed to be about a different motion, Nachmanoff has Lindsey Halligan in front of him, and he takes the occasion to ask her about the grand jury proceeding. And her answers don't help. She spoke for less than a minute, and she said that the grand jury, the full grand jury, never saw the indictment, never saw the 2-count indictment. They only saw the 3-count indictment. She confirmed that they had not seen the eventual indictment, which is the actual charging instrument of James Comey, which sounds pretty bad. An emphasis on sounds bad. But it sounds bad. And Comey's team seized on the opportunity to say, well, then there is no indictment. And suddenly this hearing became about a separate issue. Now, they got off of it and they went on to address what the hearing was actually about. But this was the headline from this hearing. And remember how with Judge Currie in the first presentation I did in this video, I showed you all of those filings that DOJ did to try and clarify the record? Well, it was also because those all occurred after this hearing when Halligan made this statement that the full grand jury hadn't seen that indictment. And so she ended up filing that portion of the transcript and like 3 filings to correct the record. And the prosecution here is on defense. And this is the second threat to this case, which could see it killed. I don't know if Nachmanoff is going to rule before Thanksgiving. But what's before him is not whether or not some violation occurred in the grand jury, the indictment's illegitimate. That's not, is my understanding, that's not what's before him. What's before him is whether or not James Comey gets this grand jury materials. However, there's something, I think it's termed a responsibility of the district court. Okay, I found it. The Supreme Court has recognized that a district court may issue or may use its supervisory power, quote, to dismiss an indictment because of misconduct before the grand jury, at least where that misconduct amounts to a violation of one of those few clear rules which were carefully drafted and approved by this court, meaning the Supreme Court, and by Congress to ensure the integrity of the grand jury's functions. The Supreme Court has also recognized that this supervisory power of federal district courts should be used to implement a remedy for violation of recognized rights, to preserve judicial integrity by ensuring that a conviction rests on the appropriate considerations validly before the jury, and finally, as a remedy designed to deter illegal conduct. Those cases are United States v. Williams and United States v. Hastings. Accordingly, when prosecutorial misconduct before the grand jury prejudices a defendant and threatens the defendant's right to fundamental fairness in the criminal process, a district court may exercise its supervisory authority to dismiss the indictment. That's United States v. Derrick. So, it sounds to me, based on that Nachmanoff could look at this and decide, yeah, there's enough here for me to dismiss this based on what has been shown to me so far. And that's why I say that this is the other threat to this case. Now, he may not do that right now. It may be that he says, I need a briefing from each side on why I should or should not dismiss this case based off of what occurred before the grand jury. But this is the other threat that is materializing. I'll say that it's materializing alongside the threat that has already materialized in the motion to dismiss for unlawful appointment. And now you have 3 judges that have looked at this grand jury material, and all 3, Nachmanoff, the district court judge, Senior Judge Currie out of South Carolina, and the magistrate judge, Fitzpatrick, all of them have looked at the grand jury proceedings in this case, and all 3 have gone, huh? What went down here? What is this? The record looks incomplete. All of them have had some question about it. And in fact, if you go to the transcript that was filed by Lindsey Halligan at the end of last week, one of the many filings that were seeking to clarify the record, which, I mean, if you need 5 filings to clarify the record of what happened before the grand jury, I think that kind of speaks to a bit of a problem. Maybe I'm out of line saying that, but I think it does. And having gone through these materials over and over again, I'm telling you, and I'll put this in a different video that I'll release either today or tomorrow. There's some things have been cleared up, but there are still discrepancies. There are still contradictions, even after all of these filings. Now, here's the I said 3 judges have looked at this and been confused. Well, guess what? The magistrate judge who received the indictment of James Comey was also confused. She says, all right, I have a report here. I have a report here of a grand jury's failure to concur in an indictment, and it's just a report that has 3 counts, and it says the grand jurors did not concur in finding an indictment in this case. And then down here she says, okay, well, she calls on Lindsey Halligan after talking to the 4-person. She calls Lindsey Halligan. She says, okay, please come to the podium. So this has never happened before. I've been handed 2 documents that are in the Mr. Comey case that are inconsistent with one another. There seems to be a discrepancy. They're both signed by the 4-person. The one that says it's a failure to concur in an indictment, it doesn't say with respect to 1 count. It looks like they failed to concur across all 3 counts. So I'm a little confused as to why I was handed 2 things with the same case number that are inconsistent. And then Halligan says, so I only reviewed the one with the 2 counts that our office redrafted when we found out about the 2 counts that were true billed. And I signed that one. I did not see the other one. I don't know where that came from. And the judge is like, you didn't see it? She says, I did not see that one. And the judge says, so your office didn't prepare the indictment that they, oh, no, says Halligan. I prepared the 3 counts. I only signed the 2 count. I don't know which one with 3 counts you have in your hands. And the judge says, okay, well, it has your signature on it. And Halligan's like, okay, well, ... And then the judge is like, all right, well, I think we need to clean up the record here. Not good. That makes 4 judges that have looked at some part, some component of the grand jury proceeding and have gone, huh? What's going on here? What took place? It's a problem. Now, personally, I hope this case goes on. I don't want it dismissed. So far, we've gotten disclosure of several documents that are pretty interesting, email threads, text messages. We haven't gotten the 4 search warrants from Arctic Haze disclosed, but we got descriptions of what those 4 search warrants were about, what they were for, what devices of Daniel Richmond's they were for, and the DOJ was ordered to file to unseal those 4 search warrants. So I think there's a good chance we might one day in the near future get to actually see the search warrants and examine those. There's been Comey's handwritten notes that got disclosed, which I want to make a different video on because I have a bit of a theory that I'm chewing on. So we've gotten all of these things thanks to this case. And I still believe, my dog is shaking my desk. I still believe, like I have from the very beginning, that this case is not about, quote unquote, getting James Comey. I believe even more so now that this case is about getting at documents, getting at disclosure. It's something else. And the posture that the case has taken on, especially in the past 2 weeks, is one of the DOJ being on defense. And it's like, to me, and maybe I'm over my skis here, okay? I'm going to go ahead and say I'm just human. Maybe I'm over my skis here. Maybe I've been reading these documents too much and having too much caffeine, which, by the way, ko-fi.com if you want to give me more. But to me, it seems like, just reading the filings, that Halligan and her team could have clarified this weeks ago, like 1 to 2 weeks ago. They could have done so in 1, maybe 2 filings. They could have explained it so much more simply. And in the hearing where she was talking to Nachmanoff, I feel like she could have explained it in such an easily understandable way and could have cleared these things up. Instead, it's like they've only cleared up little pieces of it as they've been forced to, and it's like they don't want to say too much. It's almost like they're defending around something that they isn't fully in view yet, that isn't fully exposed. And I don't even mean that in the sense that they messed up or they did something unethical or illegal. I don't mean that at all. I mean that there's something else that they're like hinging around, and they're one of my followers on X left a comment. It's like, maybe they're delaying things. Like, maybe the reason that they're hedging and they're only doing partial clarifications and they're having to keep fighting over this is because they're delaying. And I don't know that that's the case, but it's not Comey's side that's delaying things. It seems to be more defense that at first they were in a hurry to get the filter protocol because of the attorney-client privilege material. And that, I think that was because of they needed to turn over discovery. Guys, we're over a month. We're 5 weeks since discovery was due, since Rule 16 discovery was due, and they haven't turned all the Rule 16 discovery over. But so this is delaying it, and it seems like they could have cleared it up way easier, and they've caused more hearings and more filings to have to be made about this than are needed, I think. So maybe they are trying to delay the case a bit. Why would they do that? Well, maybe it's because they're working on a superseding indictment. That's my fun theory. I don't know that to be the case, but that's my fun theory on it. All right. Let me know what your theories are. I would really like to hear your theories on this case and where you think it's going or where you think it's going to end up, what you think is going on here, and whether or not you think it's going to be dismissed next week. And if it is, what do you think about that? So thank you very much. Y'all have a good weekend, and I'll see you in the next video.